Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. New Jersey, we finally get to meet. Well, we've talked about you once before, but this is going to be your first official entry into the Washington Gun Law Club. Listen, there was a big ruling that came out of New Jersey earlier this week as it relates to a lot of concealed carry laws that were passed in the wake of Bruen, and had a lot of people out here in the YouTuberverse and other platforms decrying that this was an absolutely huge victory, a complete slaughter for the state of New Jersey, and one that should be celebrated. Is it really that good? Well, I've had a chance to read the opinion. It's a long one. We'll talk about it. And yeah, there are some really, really good things to take from here, but I think that everyone might be, I don't know, overemphasizing or exaggerating what occurred here. So today, let's spend a few minutes and let's talk about how bad of a gun control beatdown did New Jersey really get? Okay, so welcome to the Washington Gun Law Club, New Jersey. Now, when you do a channel called Washington Gun Law and you're a state called New Jersey, there's really only one of two ways you're going to end up in on this channel. The first way is you do something so totally awesome, so absolutely fantastic for your citizens as far as preserving and protecting their individual civil liberties that we just feel the need to brag about you. And yes, there have been a few states that have been able to do that. Unfortunately, we don't see that very often. Now, the other way, the way that states most commonly get talked about here, is you do something so stupid, so nefarious, so terrible to your citizens to deprive them of their otherwise constitutionally guaranteed rights that we feel the need to talk about it because, well, we need to warn the rest of the country about the stupidity that's brewing in your state so it does not spill out into other states. Now, as we know, there was a great phenomenon last summer called the post-Bruen tantrum, and that is when certain states got their concealed carry laws completely eviscerated by the United States Supreme Court in the Bruen holding that had complete temper tantrums, meltdown, tissy fits, whatever you want to call them. Now, the worst state, obviously, the state to absolutely freak out the most was New York, but a close second was its close little friend there, New Jersey. Now, here's what happened. After Bruen was passed, the New Jersey State Legislature got into session and said, hey, we got to fix all of this. So they created a whole litany of new laws that included doing away with the justifiable needs. That was what they had used in their may carry type regime. But they came up with 25 new sensitive places, which basically turned the entire state of New Jersey into a sensitive place. There was a completely new process for going out and getting a concealed weapon license that included an in-person interview, plus you having to find 4 non-family references that would attest to your good character. You had to carry mandatory insurance. You were prohibited from carrying a firearm in your car no matter what. Crazy law. And interestingly enough, the groups that were actually exempt from the law would be judges, prosecutors, and attorney generals. Everyone else, though, would fall under the purview of the law. Well, in the matter of Koons v. Platkin, the case that we're talking about today, there was a motion for a statewide injunction enjoining this and many, many other restrictions that had come out of this huge legislative scheme that had come from the New Jersey Assembly. Now, there was an injunction that was granted on some of the issues, okay? So this was not a complete failure here. This was actually a pretty good day. But to say that this entire statute was completely eviscerated, completely decimated and wiped clean, that would be a gross overstatement. Now, I've had an opportunity to read the opinion, all 230 pages of it, okay? And listen, I want to commend the judge on a few things. The judge who authored the opinion is the Honorable Renee Marie Bum, okay? And with all due respect to Judge Bum, this is a very well-written, she's an excellent author. It is 230 pages. Candidly, Judge, I think you spent 160 pages doing somebody else's job, and I'll explain in a moment. When you read the body of this opinion, you would sit there and believe that the state of New Jersey is about to get slaughtered until you get to the punchline and you realize, no, they took a couple of shots to the nose and the chin here, but it is not the complete slaughter that we had heard that it was, okay? Now, one of the things I want to be critical of the judge, and there's not a lot to be critical here, but one of the things is that the judge pointed out that, you know, the government needs to provide the court with historical analogs to justify these types of restrictions. And the government, New Jersey here in this case, did no such thing. The reason the opinion is 230 pages is that the Judge Bum God bless her for this, she went out and did all of the research herself and wrote a very Scalia-like opinion here. The problem is she's doing actually the job of the state here, okay? This was not done by the state. And I want you to hear how she talked about the state's attorneys and their unwillingness to establish the simple burdens of proof that they had. Of course, then remembering that she went out and did it herself. The ruling starts off this way. Upon their initial applications, the court agreed with plaintiffs, temporarily enjoining certain provisions of the law, settling this matter down for a preliminary injunction hearing after the parties had engaged in discovery and a more complete record was developed. Remarkably, despite numerous opportunities afforded by this court to hold evidentiary hearings involving the presentation of evidence, the state called no witnesses. And despite assurances by the state that it would present sufficient historical evidence as required by Bruen to support each aspect of the new legislation, the state failed to do so. Finally, even the social science studies, which the legislature relied upon and the state adopted to support the new law, are inopposite. At this preliminary injunction stage, the state has proceeded to justify the new legislation with, quote, more of the same that it had presented during the initial proceedings for temporary restraints. This has left the court to do what the legislature had said it had done before, but clearly did not. The court has conducted its own exhaustive research into the nation's history and tradition of regulating firearms that Bruen mandates. Its analysis follows. This has taken some time, and the state's efforts to hurry this court along is most unfortunate. Moreover, instead of presenting the compelling historical evidence they promised, the state and the legislature interveners have spent their resources writing the narrative that says, absent the court's indiscriminate approval of this new legislation, the risk of dangerous and often fatal situations looms large. It is rhetoric that is not productive, particularly for this court's role here. Okay, so we're off to a good start because, hey, the state didn't do its job, right? So case over, right? No, because then what the judge does is go through a very long, lengthy analysis, which I can't get into here without making about a 35-minute video. But I can assure you what she's doing oftentimes is she is taking a look at historical traditions as to how we restricted firearms from certain people and equating that to how we can now restrict firearms from certain places. At the end of the day, and this is what I want everyone to be aware of, not only in New Jersey, but anywhere else in the country. When we get to the final ruling, okay, now here's the kicker, here's the punchline here. You read all 230 pages of this opinion, you get to the last page, all right, here we go, here's the ruling, and then the court says, oh, by the way, the ruling is in a separate order. So I had to go digging around on that and had to have Tom over at Security Gun Club actually help me out on that. Okay, when we found it, here's the ruling, okay, and I want you to be aware of this. Here's what was enjoined, okay? The sensitive place of zoos is now enjoined. The sensitive place of private property, which is open to the public, is now enjoined. What else is enjoined is the ability to carry firearms in your car, okay? So that you can do right now in New Jersey. What also has been put on pause is the in-person interview for the concealed carry license application. And what has also been enjoined is the mandatory liability insurance, okay? Those are all the things that have been enjoined, but that's it. Here's what's not been enjoined, okay? The restriction on firearms at playgrounds, the restriction on firearms at youth sports events, the restriction of firearms at airports and other transportation hubs, the restriction against firearms at healthcare facilities that provide either addiction recovery services or mental health services, the exemption for judges, prosecutors, and attorney generals, oh, that still remains in effect. The unjustified display of a weapon, a new criminal crime that really is very vague, and we're going to do a whole separate video on that. That still remains in effect. There were some fish and wildlife restrictions that were put in place as to types of ammunition that can be used. Those remain in effect, okay? The reputable person endorsement that you must get, the 4-person endorsement that you must get in order to apply for a concealed carry license, that remains in effect, okay? And the state's ability to say, you know what, we don't have enough information for the concealed carry, so we want more information and to keep you going on a fishing expedition, yeah, that is not enjoined either. So, at the end of the day, even though this is a really intelligent opinion and incredibly well written, and I don't want to think about how many hundreds of hours were spent in this, What the judge ended up doing was wasting a tremendous amount of time to do the job that the state of New Jersey could not do, and probably the reason that the state of New Jersey could not come up with the historical analogs necessary to justify all this legislation as well, they don't actually exist. At the end of the day, did the state of New Jersey get completely eviscerated in court? No, it did not. Did it take a pretty good shot on the chin? Yes, it did. Listen, we will keep track of this case. If anything else develops, we will let you know. In the meantime, if you have any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is right there in the description box. In the meantime, I do want all of you to remember, though, that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.